as well as the week following, we'll be talking about maintaining control of care in a facility. So not everyone can maintain their care at home long term. Obviously, as care needs increase, the level of care at home that you can receive may not be adequate for your needs. So, as much as we'd all love to maintain control of our care indefinitely at home, it's not always possible for everybody. So, our final webinar in this series is going to touch more on the types of things you're going to need to consider and ways in which you can maintain the best control over a longer period of time. So again, welcome everybody. So our topic today is healthcare, maintaining control over your healthcare as you age, healthcare decision making, and we'll be talking a lot about those documents that you need in place for that. So again, I'm Justin Randall. I'm an attorney with Hooper Law Office, for those of you who have not tuned in before. Our whole topic for this month is just maintaining control of things as you age. So like last week, for example, we talked about finances. Today, we'll be talking about healthcare decision making. And as I had mentioned a moment ago, we also will be talking about maintaining control of your care at home next week and at facilities the following week. Just a reminder for everybody who has tuned in before, you can send in questions with the Q&A box if you've registered through Zoom. I will see those and I will be able to answer them in real time. So this is interactive. It's supposed to be interactive. So if you have questions, please ask. I think it's helpful for everybody. One other reminder too is if you've registered, you will be receiving some materials from us after the webinar is over. One of those things is a document finder that we've created. A document finder meaning it's a little chart where you can put down the locations that you've placed your important documents at home. So whether it's in a safe or in the kitchen or where, on the coffee table, wherever it might be. But you will also receive an evaluation form. The evaluation is for you to fill out for a couple of reasons. One, it kind of lets us know how we've done, or if you have any suggested topics or things that we could improve on, that's really helpful for us to keep this process improving. Another part of that evaluation is if any of this raises any concerns for you or your family, anything I talk about today, that is how we know if you would like us to set up an initial consultation or to reach out to you to set one of those up. You do not have to fill that part out, but if it is something you'd like us to do and reach out to you, then you absolutely mark down that you'd like us to do so. And we do free 2-hour consultations so that we can spend the time to get to know you and your family a little bit and your situation. But yeah, absolutely. If any of this raises concerns for you, please don't hesitate to fill that part out and send it in. We won't reach out to you if you don't put anything in there, only if you do. So we do need your permission first. But again, so our topic today, maintaining control over healthcare decisions. That is, financial decisions are something that a lot of people think about initially when they're talking about maintaining control as they age. Financial decision-making is the thing that is more involved in your day-to-day life as opposed to healthcare decisions. But that being said, healthcare decisions are just as important to consider as you age, and making sure that someone can step in and help you if you need that. So there's a couple key documents you're going to really want to have to make sure that you have the right tools in place for people to help you. So first and foremost, kind of something I'm sure you've all heard of, is a healthcare power of attorney. So a healthcare power of attorney, sort of like a financial power of attorney, is a document in which you list people that you want to be able to step in and make decisions for you regarding your healthcare, should you not be able to make those decisions yourself. So there's a couple key considerations that you want to have, or that you want to think about before you name people on that document. First and foremost, are they trustworthy? Do you trust them to follow your wishes? That should be kind of a no-brainer, right? You want to trust the people you're naming, but the first and foremost, that's the biggest consideration. For healthcare, location can matter a little bit more than it would, for example, with a financial power of attorney, because financial decisions, a lot of that can be done online or over the phone. Healthcare, if they're the ones, people who are going to step in and help you with those decisions, they may need to go to the doctor with you. So it's a lot easier for someone nearby to um, to do that for you than someone across the country. But that being said, if you only have someone across the country and that's the person you trust the most, absolutely still name that person. It's still better than nothing at all. It's still a good option. You just, if you have kind of two equally trusted options, you need to pick one. Sometimes the closer option is better. The other thing that a lot of people don't think about when they're naming someone as a power of attorney for healthcare agent is the end of life aspect of that. So the healthcare power of attorney agent, along with your attending physician at the time, if you are on life support, the two of them are going to have to decide it's time to remove you or keep you on life support, depending on what your wishes are. So if your wish is to be removed from life support, if there isn't a chance of recovery, then you need to make sure the person you name as a healthcare power of attorney is, one, aware of those wishes, and two, okay making that decision at the time. Because in theory, if the person you've named is not comfortable making that decision, which is understandable, it's not an easy thing to do. So there's no shame in that. It's just that if they are uncomfortable doing it and are ultimately going to be unwilling to do it, they may not be the right person to name as the initial agent at the very least, because that could get in the way of what your wishes are. So what I always recommend people do is when you're setting one of these up, talk to the agent you've named and all of the agents that you've named as potential backups to clarify what your wishes are and make sure that they understand coming from you verbally what those are. And then you know in advance, if they say, I'm not comfortable making that decision, you know well before they'll ever need to make that decision, then that maybe you need to reconsider who you name, at least as an initial agent. So there is a question here of what can I do if I don't have anyone I trust to act as my power of attorney? So there are a lot of good options for that. There are for financial reasons or side of things, with a financial power of attorney, you can always name a corporate fiduciary. So a corporate, the same types of people who would be like a corporate trustee. So sometimes banks can act as your corporate fiduciary for power of attorney for finance. There's a number of organizations, here in the Fox Valley that act as corporate fiduciaries as well. So those can essentially be corporate powers of attorney. With healthcare, there's a lot of different organizations that do that as well, sort of as a healthcare agent. They can step in and help make healthcare decisions for you, sort of act as advocates for you. You still want to look into those options. It's always ideal if you can name an individual first. I think that's always the first choice for these things. But if you can't, look at these care organizations or these advocate organizations that can do that for you as well. It is much better to have one of those down than nothing at all, certainly, and they're good at what they do. The other thing I would say too is possibly think outside the box maybe a little bit with who you're naming. And by that I mean it doesn't necessarily have to be a family member, right? Do you have close friends? Do you have trusted colleagues, anything like that you could name and that you feel comfortable naming in that role? So it doesn't have to necessarily be a son or a daughter or a husband or a wife. If you're single and don't have kids, maybe you have extended family that you trust to do that. If not, then absolutely look at some of these organizations to name in that role instead. It's definitely better than the alternative. If you don't have a power of attorney, as we've discussed previously in other webinars, if you don't have powers of attorney in place and something happens to you, the only way anyone can step in and make decisions is through guardianship, a process known as guardianship, which is a court process. And if you already have trouble finding someone to name as an individual, that can be even more difficult of a process, because then it sort of is much more difficult for anyone to know that needs to be done. Usually it's a family member that petitions the court for that, for guardianship, or a close friend sometimes as well. So that's how I would go about that if you don't have an individual. Okay. And I did just get, I may be breaking up. So if you have trouble hearing me, I apologize. I'll try to see what I can do with that. Um, all right. Okay. Hopefully it keeps going for everybody. But if that ends up being a big issue, I'll see what I can do. I'm not the most tech savvy person myself, unfortunately. Um, okay. So I apologize if you're having trouble hearing me at all, or if I'm breaking up. The uh, the next document that you want to consider having in place for healthcare decisions is what many of you, I'm sure, have signed in the past, is a HIPAA authorization. So most of us have signed these in the past. It's a document the doctor often uses. To make sure that they can talk to your family members or other individuals that they would need to talk to. Without someone being named on a HIPAA authorization, they are not entitled to any information from healthcare providers, and that includes family members somewhat. Spouses are entitled to some level of information because of marital property rights and marital laws, but it's still not unlimited potentially. And so it's much better to name them intentionally on a HIPAA authorization than it is to rely on those legal protections that they may have, because then you're just being very clear what your wish is on that. But in general, any other family members, whether it's your kids, siblings, parents, anything like that, you absolutely, if you want them to be able to find out what's going on with you, if you're in the hospital or you have a health event, you want them on a HIPAA authorization. For example, this is not just about maintaining control as you age necessarily, but anyone over the age of 18 should have a HIPAA authorization with at least their parents on there if you're a college student, things like that. Because otherwise, the moment someone turns 18, parents are no longer legally entitled to any information about their child healthcare wise. So it's important to make sure that anybody you want to get health information has some HIPAA authorization, or you've signed a HIPAA authorization with those people listed. Um, the uh, the other document, kind of main document that tends to relate to healthcare decision making and maintaining your wishes in those with those decisions, is a living will. So a living will is not a last will and testament. It's not saying where you want your property to go. A living will is a document in which you list and explain what your end of life wishes are. So if you are on a ventilator or a feeding tube and you're not going to recover, and the doctor says it's medically that you're not likely to recover, then that's where you say, well, my wish is to be removed from those care options at that point, and maybe be made as comfortable as possible. It's where you are able to explain that to not only a healthcare agent but a care provider as well. Now, like I mentioned previously, if a power of attorney agent is unable or unwilling to make that decision for you, that could get in the way of those things. Now, that being said, if they are able to make that decision, perfect for that. But also, that living will acts as legal protection for them somewhat, because then they're able to point to that document and say, "Hey, I was just following mom and dad's wishes." If for whatever reason somebody challenged that decision, right? Hopefully, no one does, because it's already a hard enough process to go through emotionally and mentally. But if somebody did, for whatever reason, challenge their decision on that, they would have that document to point to and say, "Hey, I was just following their wishes. I didn't do this because I wanted to. It was their wish, and I was enacting it for them." Uh, with these documents, it's important to consider a couple things going forward once you have them in place. So, especially with a healthcare power of attorney and a living will, once you have them signed, especially if you've had them drafted for you, you want to make sure that your doctor has your custom drafted ones on file. You want to be careful about signing new ones going forward, because if you sign a new healthcare power of attorney or a new living will, you potentially revoke the old ones, and you likely have. So if you're for example, your healthcare power of attorney says, I don't need a declaration of incapacity for my son or my daughter or my husband or wife to step in and help make decisions for me, but the doctor's does, that may get in the way of the decisions you needed made for you if that wasn't your intention. So it's much more important to make sure that they have your drafted ones on file than signing a new one everywhere you go, because it can just constantly revoke the old ones. And if you put it on file with your primary care physician, they should be able to spread it across their entire health network. So you don't have to worry about going to every hospital and in the area and putting these on file. But with a HIPAA, it's a little less concerning because those don't necessarily revoke old HIPAAs. So, you may have signed dozens of HIPAAs and that's okay. That's maybe institution by institution. And they're not always going to be named the same thing. These documents are not always called exactly the same thing. So for example, in our office, we call it a healthcare power of attorney or a power of attorney for healthcare. But oftentimes at a doctor's office, you'll see these documents all sort of in one document called an advanced care directive. So that's kind of the thing you want to keep in mind of, if you see that, just be very conscientious about what you're signing. Don't just sign things and fill them out and then turn it in, because you may have unknowingly disrupted your own planning. So one of the questions I just got is, my daughter's my power of attorney for finance, but my bank refused to give her information on my account. How can I make sure they give her information she needs? So for that, they shouldn't be able to refuse that. There is a lot of times banks will not immediately honor powers of attorney for finance, but that is not something that they're supposed to do. There is legal repercussions for them potentially if they refuse to honor a perfectly valid power of attorney. And part of that, I apologize for the siren going by. If they refuse to honor a power of attorney, there's legal protections for you saying that if they ever got sued for that, they have to pay all the attorney's fees, and that's usually enough to get them to go ahead and follow through on honoring it. But it can maybe help too if you go in with them, with your daughter, and say, I'm giving them permission, or you call the bank yourself and say, they have my okay for you to talk to them. There's no real HIPAA authorization for finances, right? It's sort of more just a release of information or a consent to release information, which having a power of attorney for finance, as long as that power of attorney has the right authorities in it, meaning things like, I can go to the bank on behalf of the person I'm, my mom or my dad, that should be enough. So that would be the first thing I'd try is maybe talk to them first and say, why won't you do this? And I have this power of attorney signed. Sometimes you have to sign a form at the bank or their form for them to be okay with that, but they don't have any real reason unless they have concerns that it is, an invalid power of attorney, meaning that somebody had revoked it to refuse to honor it. So hopefully that helps. It can be a bit of a tricky situation sometimes with those where not because banks are trying to or institutions are trying to get in the way of these things, but they may not understand what the rules are. They may not understand these documents all that well. It's the same way I wouldn't necessarily understand the stock market if somebody came to me with information about that. They're not attorneys, so they don't understand what the law is necessarily. They may be following the bank's internal rules on that, but it doesn't mean that if you have this properly signed that it shouldn't work. That's definitely the first and foremost thing I would do. If you still run into trouble with that, I would definitely come talk to an attorney and see what you can do to fix that problem, because they should not be refusing to answer those questions or to talk to her if she needs to. Otherwise, what's the point of having that document, right? So the one thing to keep in mind too with your agents of naming healthcare powers of attorney agents, that is that sometimes with financial powers of attorney, people will have co-agents. They'll say, "Oh, all of my kids, if you have two kids, my two kids are equal agents. Both of them can act on my behalf at any time." With healthcare, you can't do that, unfortunately. So if you have multiple people that you want to name, you do have to pick an order, and that's just because of the way the statute's written and how it's been interpreted. It talks about any individual at any time, meaning it's never fun to pick and choose your kids over one another, but you may have to do that for this purpose anyway. And it's no hard feelings to them. It's just what the law requires. Um, like I mentioned, having these in an accessible place is really important too. If people don't know where these documents are, they're not going to do anybody any good when they need to use them. So not only keeping them on file with the healthcare provider, the your health network, or if you have like online access to your doctor's records, which I do through ThedaCare, for example, you can upload your documents there as well so that they're available across the entire network. The other thing too with these documents at home is making sure that, like we have this document finder you should be receiving from us at the end of this if you've registered, that making sure your family knows where to look, or if the attorney has it on file, making sure that your kids know which attorney you work with to call them if they need it, and that the attorney has the authorization to talk to your kids. There's a lot of these things that interplay with one another, making sure that anybody that you need to act on your behalf not only has the legal authority to do so, but knows where those documents are. Because you could have signed these, but if no one knows where they are and you can't provide a copy to anybody, they're also not going to do you any good. So a lot of times what we'll do with kids of parents is, if most people have smartphones these days, we can send digital copies to people and make sure that they have it on their phone, so that you don't have to carry a binder with you everywhere you go, carry physical copies. You can just have it on your phone, and that way they will always have it if they ever need to show it. There's also services you can use. There's Legal Vault is one that we used in the past and occasionally still use for people. If there's any issues with finding those documents, there are services you can use. The one thing I like to point out to people too is making sure that anybody who is a healthcare power of attorney has a HIPAA authorization. That is something that gets missed occasionally. So our healthcare powers of attorney, for example, do have a HIPAA authorization included in the document itself, and we also have a separate HIPAA authorization. So we're really making sure that your agents have the access to that healthcare information. But if they don't, I've seen this happen before, where somebody was a healthcare power of attorney and there was no HIPAA authorization included in the healthcare power of attorney, and they did not have a separate signed HIPAA authorization, and they also didn't have the capacity to sign new documents anymore. So what happened is there was sort of the standstill between the healthcare powers of attorney and the doctor's office, where they wouldn't give them information because there was no HIPAA authorization, and that was their stance on that. And the people needed to step in, the kids needed to step in and help make decisions, but they also couldn't get any information to make those decisions. So this is not just one document that you want in place, and it's not necessarily if you have just a HIPAA authorization, that doesn't mean people are going to make healthcare decisions for you or have the right to. And it also doesn't mean that if you have a healthcare power of attorney, if there isn't somewhere in that document or in a separate document that says, it is a HIPAA authorization and you're giving them the right to that access that information, well, they may not have trouble making that decision, or they may not even be able to talk to the doctor to make that decision. So you don't, it's not just one of these that you need, it is all of them. And keeping in mind that you want to name people you trust, and those people who are named know they've been named, and where those documents are is essential to making sure that they have the access to that information, and that they will be able to step in and make decisions for you should something go wrong and you not be able to make those decisions yourself. there's a lot of ways that things can go wrong if you don't have these documents in place. Like I said, if you have to go through guardianship, if you don't have a healthcare power of attorney signed and you don't have the capacity to sign one anymore, it's something you can avoid potentially by having a healthcare power of attorney in place. You don't necessarily need to go through guardianship unless someone is potentially causing harm to themselves or to others. That's something no power of attorney in the world is going to stop. You have to potentially go through guardianship to prevent that from happening. So I know I've been having some technical difficulties here, so hopefully this was the recording turns out okay. If not, I'd be happy to talk to anybody that has any additional questions. I know this isn't ideal with it breaking up, but we'll see what we can do. And if anything I raised is concerning to you or any of your family members, please remember to fill out that evaluation form and let us know that you would like us to reach out to you to set a time to talk. But thank you all for joining us today. And if, like I said, if any questions come up, please feel free to contact us or to set up an initial consultation. Again, those don't cost you anything to come in and talk to us. We need to be able to know what your situation is before we can make any recommendations. And be sure to tune in for our next webinars coming up here with, in the next couple of weeks, where we have taking care at home and making sure you maintain control at home, as well as maintaining control once or if you ever need care in a facility. There's a lot of things that you want to keep in mind, not only where you receive care, but what type of care you might need in those facilities, and making sure, especially with everything going on right now, that your loved ones have what they need to help maintain the quality of care that you would need or that you would like to have, and the quality of life that you deserve at that point. So register for those at estateplanninglive.com. That's where you can register for all of this. You'll receive an invitation for the Zoom, or you can always watch it on Facebook Live. If you don't register for Zoom, though, you may not receive our materials. So that's just how we know who to send things to. But if you would like to receive those materials and potentially set up an initial consultation, estateplanninglive.com lets us know who to send those to. So thanks again, everybody. And again, I apologize for the tech difficulties, but you can always watch the replay. And Nicole, our tech help for this webinar, is telling me we'll send you an email with that replay as well. So thank you all for joining me. And I apologize for it being a little hard to understand if I've been breaking up, but thank you, everybody. And we'll see you next week.